I came across a rather heated discussion in the comment section just recently where somebody was trying to say that you do not have to give your name and address if you are involved in a road traffic collision. So in this video, I'm going to talk to you about Section 170 of the Road Traffic Act 1988. But there's also an interesting trivia for Freemen on the Land and vehicles at the end of the video, so make sure you watch till the end. So as usual, there is a short version and there is a long version. The short version is if you are involved in any kind of collision, you do have to stop and give your name and address, and in some circumstances you have to report the incident. The long version, I'm going to go to Section 170 of the Road Traffic Act, as I mentioned. Section 170 provides that there is a duty on the driver to stop, report an accident, and give information or documents in certain situations. Right off the bat, and probably the most important one, is Section 1A, where there is a personal injury caused to a person other than the driver of that vehicle. So this section applies where, owing to the presence of a mechanically propelled vehicle on a road or other public place, an accident occurs by which an injury is caused to another person other than driving that vehicle. And so just pausing to go over some of the words there, a public place includes a car park. Some people have again tried to say that if it's a car park, that doesn't apply because it's very often private land. But private land should not be confused with a public place. A public place is anywhere that the public have access on payment or otherwise, even though that might be a private area. Whether it's closed or not might make a difference, because let's say it's a pub car park and they have closed the barriers and then somebody goes on to that without permission somehow through the barriers, or they're already there, then it's no longer a public place because it's closed to the public. The public do not generally have access to it. That might cause certain problems. But I digress. Any road or other public place, if there is a road traffic collision in which a personal injury is caused to a person other than the person driving that vehicle, this section applies. Under 1B, this section also applies if, and there are three sublimbs to this, 1. Damage is caused to a vehicle other than that vehicle, or a trailer drawn by that vehicle, or, under 2, damage caused to an animal other than an animal in or on that vehicle, or a trailer drawn by that vehicle, and under 3, to any property, and this one's fairly broad, to any property constructed on, fixed to, growing in, or otherwise forming part of the land on which the road or place in question is situated, or land adjacent to such land. In other words, if you drive your vehicle into a wall or a lamppost, this section applies, so listen on. Now, having set out the circumstances in which this section of the Act applies, let's look at number 2 and see what applies. Under subsection 2, the driver of the mechanically propelled vehicle must stop, and if required to do so by a person having reasonable grounds for so requiring, give his name and address, and also the name and address of the owner and identification marks of the vehicle. This is important because there are two sublims within Part 2 here, even though they are not set out. First of all, the name and address of the person driving the vehicle. Secondly, if different, the name and address of the owner of that vehicle, together with, of course, the identification marks of the vehicle, which just means the number plate. So again, doubtless, some people have argued that you only need to give the name and address of the driver, or conversely, that you only need to give the name and address of the owner of the vehicle, neither of which is true. You must give the name and address of both people, in circumstances where required to do so, where any person has a reasonable ground for requiring such information. And that isn't a very high bar. A reasonable ground for requiring that information could just be that you've scraped the vehicle very mildly. Again, doubtless some people might argue that if you've only just touched the vehicle, then they can just take the registration plate of your car and be on their way. And of course, that's not true either. Any reasonable ground and any damage whatever to the vehicle would be a reasonable ground for requiring that information, because they might want to sue you or report you to their insurance company so they can sue you or claim from your insurance. And of course, in situations where it's much more serious and there's an injury caused, that is very much more than just a reasonable ground for requiring that information. They they can require, in those circumstances, both your name and address and the name and address of the owner of the vehicle, if different. But as I said, there's more than one bit within subsection 2, which is the driver of that vehicle must stop. So if you don't stop, or fail to stop as it's referred to in the sentencing guidelines, which I'm going to come back to a bit later, then you are in breach of subsection 2, where this section applies, which we've detailed from section 1. There is a very slight get-out clause in subsection 3, although I wouldn't suggest you rely on this. This is really a catch-all situation. Subsection 3 provides that if, for any reason, the driver of the vehicle does not give his name and address, under subsection 2, he must report the accident, and obviously that means report it to the police. And then, just for the avoidance of doubt, subsection 4 clarifies that a person who fails to comply with subsection 2 or 3 above is guilty of an offence. But now coming back to one of the sections which I said was quite important, which was sub 1a, remember, where an injury is caused, subsection 5 deals with this a little bit further. It says, if in a case where this section applies by virtue of subsection 1a, i.e. an injury is caused, if the driver of the vehicle does not at the time of the accident produce an insurance certificate or other evidence, as mentioned elsewhere in the Act, either to the police constable or to some other person having reasonable grounds, as we've just discussed, for doing so, requiring him to produce it, then again the driver must report the accident and produce such an insurance certificate or other evidence. That might just be evidence that the vehicle is insured. And as I said, it must be reported to a police officer, which is detailed further in subsection 6. That is, that it must be done at a police station or to a constable, and must be done as soon as is reasonably practicable, and in any case within 24 hours of the occurrence of the accident. It's no good waiting 3 days or a week to then trot off to the police station to take your insurance certificate. It must be done within 24 hours if you haven't done so already, and otherwise, yet again, you will be in breach of this section and committing an offence. And once again, there is a very slight caveat under subsection 7, which provides that a person who fails to comply with the duty under subsection 5 above, that was in the case where in the event of an injury you must produce that insurance certificate to a constable or the person requiring it, he shall not be convicted by reason only of a failure to produce the certificate or evidence if within 7 days after the occurrence of the accident the certificate or other evidence is produced at a police station that was specified by him at the time when the accident was reported. In other words, you must first report the accident and then say that within 7 days you will take said evidence. So just before I move to the bit of trivia for the freeman of the land and deregistration of a vehicle, I'm going to talk briefly about the sentencing guidelines for the failure to stop and report an accident, which was revised in 2017. As with most offences, there are 3 categories, and they are determined by culpability and harm. Obviously, the higher the culpability and the greater the harm, the higher the category. Category 1 being the most severe. An example of a Category 1 might be where there is serious damage or serious harm to another person. Perhaps the person is evading the police for another offence and perhaps giving false details, all of which would be in breach of Section 170 and obviously trying to evade liability for something else. Other aggravating factors that might make this even more serious are previous convictions. For example, previous driving convictions such as drink driving or serious speeding offences, or careless or dangerous driving convictions. There might be little or no attempt to comply with your duty. There might be evidence that there was bad driving or failure to comply with current orders, such as if your driving was disqualified. That is an order of the court banning you from driving. It's an order that you must not drive. Some factors that might mitigate this situation and make it a little less serious might be those completely opposite, such as you have no previous convictions, you are remorseful, you're of otherwise good character, you made every effort to comply, and you had a genuine fear of what was going to happen if you did provide your details to the other driver. For example, there's a road rage incident and someone gets out and they are literally threatening your life. Quite obviously, you might be terrified to give your name and address to that person. So whilst you are technically committing the offence of failure to stop, if they then report you to the police for failing to stop and provide your details, if you responded to this allegation by saying you were in fear for your own safety and perhaps even your life and therefore didn't comply and didn't give your details, this I imagine would be a fairly strong mitigating factor and the court would take that into account. But overall, and just for the avoidance of doubt, you do have to stop and provide your name and address and, if necessary, the insurance certificate as I've just explained. But as for the little trivia of deregistration registering your vehicle as your own private property and therefore having no legislation apply to it, so say some freemen of the land. One such notice that I found online was titled Notice of Understanding and Claim of Right. And it says, and I quote, "It is my understanding that any statute by which you claim to use to back any claim you may make on my car can only be valid if I consent to those statutes." Some people saying that if they deregister their vehicle from the DVLA and disavow any consent to Acts of Parliament, that somehow this means that their vehicle is then their own private property, private carriage, and the Acts of law do not apply to them. Just for the avoidance of doubt, this is completely false. Your consent is not required for Acts of Parliament to apply to you, and if anyone were to test that out to the extreme, you will find yourself in court under a bench warrant if necessary. You will quite possibly be fined or even imprisoned for whatever the offence was committed with your vehicle, and then, dare I say, find out that these acts and offences do apply to you whether you consent or not. So just to reiterate, your consent is not required for Acts of Parliament or for any law for that matter to apply to you. That is not how this consent works. Common consent, or consent of the governed as it's often referred to, does not apply in this way. It does not mean that if you don't consent to the acts to apply to you that they don't apply to you. That's simply not how it works. But I hope you found that trivia interesting. Please do smash the like button and remember to subscribe, and as always, thank you for watching.